Hearing in the appeal, Attorney General of Trinidad and Tobago against J.M., a minor by his kin and next friend N.M.
I should begin by indicating that the Board has ordered that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the child or any member of his family in relation to these proceedings. Mr. Ramlin.
Deeply obliged, my Lord. My Lord, I appear for the appellant, and with me is Mr. Robert Strand and Mr. Adam Riley of the UK Bar, and my little friend Mr. Howard Stevens, King's Counsel, and Ms. Catherine Bailey appear for the respondent. My Lord, this is an appeal against an assessment of damages arising out of an important constitutional claim for a minor. And we say that the Court of Appeal committed 4 errors. The first is it reversed the trial judge's award of vindicatory damages on the ground that there was no evidence of institutional malafides, and institutional inertia was insufficient to ground an award of vindicatory damages. We say that that is not a necessary ingredient to justify an award for vindicatory damages. The court also erred in finding that there was no evidence of cruel and unusual punishment because there was no deliberate intention or malice or no deliberate pattern of conduct that targeted J.M. Thirdly, the court erred in finding that there was no justification for having a different per diem for calculating the award of compensation at the time spent at St. Michael's as opposed to St. Anne's, the psychiatric institution. And finally, the minor's detention prior to the conviction of the mother, they erred in finding that that period was lawful.
So the fourth point, sir?
That the minor's detention prior to the conviction of the
That's from July 2012 to September 2014.
Correct, my Lord.
Yes.
Yes. Now, my Lord, this case concerns a minor who had a very rare genetic disorder that was not detected until he was 9 years old. After he was a mere 4 months in the care of the state from the 17th of September 2021 to January 2013. The disorder, Prader-Willi syndrome, is not untreatable. In fact, the evidence will show that treatment plans were devised but never implemented. And having not treated that condition and placed the minor in a position where his vulnerability could reasonably and easily have been exploited, we say it would be wrong to hold against the minor the natural manifestations and symptoms that would be associated with this disorder. And to that extent, my lords, my lady, I say that when one reads the Court of Appeal's judgment, there appears to be some undercurrent of subconscious influence in terms of the symptoms and manifestations and the behavior of the minor. And to that extent, we say that that ought not to have influenced the judgment of the court. In the same way, you couldn't blame the child for having a rare genetic disorder that he had no control over. Likewise, you couldn't ascribe to the child blame that would attach to the mother. The mother's conduct, her circumstances, and her attitude towards the minor would quite frankly be irrelevant in assessing damages due to the minor. And we say, my lords, that in constitutional law, it is well established now since the board decided in Mohanlal Bhagwandin and the Attorney General over 2 decades ago that there is no need to prove mala fides, hostile intention, a deliberate pattern of conduct that targets one to justify the breach of a fundamental right enshrined in the Constitution, nor indeed to trigger an award of vindicatory damages. This was an entirely exceptional case, unprecedented in nature, and therefore the judge was correct, we say, to award vindicatory damages in the sum of $1 million. We say that cherry-picking the evidence and dissecting it, as the Court of Appeal did, does not necessarily do justice to the case, because there are gaps that reveal themselves when you adopt such an approach. And the trial court judge was correct to look at the evidence, take a panoramic overview of the evidence, and to take the evidence on the totality of the evidence. And on the totality of the evidence, taking it in the round to say that it justified an award of vindicatory damages. And that decision could hardly be described as plainly wrong. We say further that institutional inertia, as opposed to deliberate conduct or malice, can have just as devastating consequences, as the facts of this case amply illustrate. It's a results-oriented approach, and one has to look at the pain and suffering and the harm that the minor suffered, and not the intention and the motivation that led to that. My Lord, the issue of cruel and unusual punishment.
It's a rather...
Sorry, my Lord.
The pain and harm can be covered by compensatory damages, can't it?
It can, yes, I accept that.
For vindicatory damages, it's intended to be emphasising the importance of the right, isn't it?
Yes, the gravity of the breach, yes. The importance of the right. Yes, I accept that, my Lord, yes. There would be some area of overlap, because the severity of the breach and the gravity of the breach is obviously oftentimes what would also trigger an award of vindicatory damages. But I accept that, yes, my Lord. And of course, I mean, the award of vindicatory damages serves many functions. I mean, it's also there to ensure that it acts as a deterrent as well, to ensure that it sends, the court's conscience is pricked and outraged to such an extent it needs to send a clear message and signal that this is unacceptable.
But wasn't one of the things that the Court of Appeal took into account that after that at the time that they were considering the matter, he was being cared for at considerable expense, as they mentioned a couple of times in the judgment, by 12 dedicated nurses, so that perhaps the deterrent element was not required in this case?
Well, my lady, the circumstances in which that occurred was the basis of an emergency application for interim relief to the court. And but for the court's intervention in this matter on the basis of that application and the orders made by the court, the child would probably still be in the psychiatric institution.
The orders that led him to be taken to the child care centre?
Yes. Yes, those orders were made as a direct result of this matter. We sought urgent interim protection and relief for the child to be removed from St. Anne's because it's an adult psychiatric institution that caters for insane people. And as a result of that, the child was removed. But that does not obviate the necessity for the court to say the status quo that confronted the court is a matter that cannot be should never have arisen and should never be tolerated in a civilized democratic society. So I think the award of vindicatory damages is to send a message. Milady, had the child been properly cared for, we would not have reached the stage where the state had to incur that expense to have the child on an entire floor and being cared for to that extent.
Really? Why do you say that?
I say that, my lady, because A, they had developed, Prader-Willi syndrome is treatable, as evidenced by the fact that they had developed a treatment plan for this child, and the treatment plan was never implemented or discontinued. If the treatment plan had gone according to plan and they implemented it, and that was being done in an environment that was conducive to his rehabilitation, then, milady, he would not have deteriorated to that stage. But the point
we don't know that. That's speculation.
Well,
but I mean, you're able to say that at least a treatment plan might have had that effect of alleviating subsequent problems.
well, yes, my lord.
We've got no evidence to help us.
No.
Otherwise.
Yes. Well, look, Trinidad is a very small society, and getting expert evidence, most of the experts in a niche area like this would already be attached or affiliated in some way with the state. So it's extremely difficult, if not impossible, to get independent medical evidence. And that is why, to the extent that is a very irrelevant observation, my lord, I just put that on the record. Now, can I, my lords, start by taking you through some of the salient points, the evidence that I'd like to bring to your attention. And I'll start by taking you to the electronic bundle, page 944. And at page 944, this is the affidavit of the mother. And at 944, paragraph 23, she says, he was also the victim of constant sexual harassment and abuse by both staff and residents who would force him to perform sexual favors. On several occasions when I visited him, he would break down in tears to me while telling me of his experience at the home and some of the things he had to do. On more than one occasion, he told me he was made to perform oral sex on male residents of the home, and on occasions when he refused, they became aggressive and would beat him. Many times I would visit him, and he would have large blue-black marks about his body. When I asked him about it, he would tell me that he got it from licks from the other boys. Scrolling down to the next page. Whenever I visited him at the home, he would constantly express his misery regarding the treatment meted out to him and the sexual and physical abuse he was being forced to endure. Sometimes he would just throw himself on the floor, cry and beg to be taken home. My heart would break every time, as there is not much, there's not much because I'm poor and my child was taken from me by the state. As a result of numerous complaints, Ms. Sullivan, the social worker at the home, and I made several reports to the Four Roads police station about the treatment meted out to him by residents and staff, especially about bullying, beatings, and sexual abuse. Now, I pause there. Because when I take you through the evidence, my lady, you will notice throughout the course of it, it's punctuated with reports to relevant state agencies and entities that are charged with the responsibility for investigating, bringing to justice, and taking preventative action. And what you will find throughout is that there is no resolution, no action taken, no evidence. And this is the first example of that. I take you next to page 946, which is if we scroll down. And might I just add, all of the evidence that we have exhibited came via painstaking collateral freedom of information applications. In fact, that was itself the subject of a claim for judicial review. It's not like the mother had all this information readily available at her fingertips. It came as a result of freedom of information applications which were hotly contested in court, and as a result of claims for judicial review to get disclosure, full and frank disclosure of these records. At paragraph 28 on page 946, On October 6, 2016, the situation at the home escalated to the point where he was beaten with a piece of hot iron by another resident of the home. He was taken to the St. Anne's Psychiatric Hospital urgently by Ms. Sullivan and Ms. Lala, the court officer and home supervisor, respectively, due to the nature of the injuries he sustained. Lower down that same. In the medical report, Dr. Pear stated that he had bodily scars consistent of burns and multiple scars about his chest, abdomen, arms, and face. It was also stated that the court officer stated that he had been abused at the home, being a victim of aggression and torture. The home's supervisor also reiterates abuse and violent behavior against him. Nobody had the courtesy to inform me about this incident. I was only informed in a casual manner and given sketchy details when I visited him a few days later. In fact, it is only now I know that a report was actually written by a medical doctor about this incident because of my Freedom of Information application. Now, this is interesting because the child is beaten with a piece of hot iron, and when he goes to be examined medically, the doctor notes bodily scars consistent with burns and multiple scars to chest, abdomen, arms, and face. And this is a classic example of why I say the trial judge was correct to take a panoramic overview of the evidence and assess the evidence in the round on the totality of the evidence, because one cannot say how those bodily scars came into existence, whether it was as a result of one single act of violence or whether it was as a result of multiple acts over a prolonged period of time, one does not know. But clearly, when we come to the evidence lower down, you will see evidence of cigarette burns and other evidence that gives rise to the inference that the abuse was on a more prolonged and sustained basis. Can I take you next to page 951? And at page 951, paragraph 40, the mother was so frustrated, she's literally knocking around, and she is forced to go public. So her pain manifests itself in going public, and an article was published in the leading Trinidad Guardian newspaper. Mother claims son, 14, physically sexually abused at boy's home. And it was reported, officials said while a healthcare plan had been developed under the old administration, this was not the case. It was scrapped when the reins switched hands. And then at paragraph 43, low on the page, when the mother visited him at St. Anne's Hospital, Joshua was no longer allowed to use his phone. She was prohibited from taking a picture with her son, and she said he was being treated as a prisoner for no reason. The nurses informed her she's not allowed to bring Joshua's sisters to visit him since they're too young, one being 10 years and the other being 12, but he misses them and would always ask to see them when she visits. Now, you will see that visits with the sisters would obviously have helped in his rehabilitation. It's in the reports. Can I take you next to page 55?
955.
55. And page 55, this is the order that was made by the Learned Trial Judge on the interim on the application for urgent interim relief on the 9th of October 2017. And at paragraph 3, she ordered that the child be placed in the care and control of the Children's Authority forthwith, specifically at the Child Support Center until further ordered, and that a team of specialists and medical experts attached to the Children's Authority do conduct appropriate assessments and examinations. Now, the word forthwith is used, and the order was made on the 9th of October. And you will see from the evidence that we had to go back to court because essentially the order was not being complied with and no one was saying anything. And you will see that at page 58. Page 58, we wrote to say, well, look, could you confirm, this is we're writing counsel at the Children's Authority, to say, could you confirm that the child has been removed from St. Anne's Hospital in accordance with the forthwith order and moved to the Child Support Centre? And could you indicate what arrangements will be made to allow the mother and two sisters to visit him as soon as possible? And the context for that is because, you know, as the mother says in her evidence, she didn't know where they'd taken the child. No one was telling her where he was, if she can visit, and she wanted to have access. That in the face of the order made by the judge forthwith. Now, I go next to page 967. And this is, 967 is the transcript from the magistrate's court that would have dealt with the mother's case with respect to abandonment of the children. And what I asked the board to note is this, and I'll take you through this a couple. On the 26th of September 2012, complainant appears, accused appears, owner and manager of Ferdine's Children's Home can't manage the child, aggressive, fighting other children, climbing over the gate, eating at 8 a.m., defecating, and he's remanded at St. Dominic's home in Belmont and remanded, bail is fixed. Now, the evidence shows, and it's not recorded, that the child during that period spent a night at YTC, which is in fact, YTC is for offenders who are serving time, juveniles who are serving time. He spent a night there. The child is 9 years old. YTC is for boys 16 to 18. YTC is for boys 16 to 18 years of age. And a 9-year-old child spends a night there. And then he spends a night, we'll see later on in the police station. If I take you to the fourth entry at 29/11/12, you will see that from there on, complainant appears virtual complainant remanded in custody in absentia. Now, my lords, throughout this matter, this child was not being brought to court. And you will see he was remanded in custody. Well, he wasn't in custody, as the trial judge noted. He was never an offender. He was a victim. But the language and the Court of Appeal was wrong, we say, to find that the trial judge was not entitled to make a finding that they were treating the child as though he was a youth offender rather than a victim. The language is consistent with that of an offender. He's remanded in custody. But what I ask you to note, my lords, and we've checked it, this matter was called on 30 separate occasions. And out of those 30 occasions, on 20 occasions, the child was never brought to court. And the magistrate continued to simply say, remand in absentia. You will see it on the entry of the 29th of 11th.
When it says virtual complainant, does that mean some sort of online attendance?
That's the child, yes, my lord.
No. Absentia.
No.
It does.
Oh, no, sorry, no.
What does virtual mean?
It speaks to the, forgive me, Mike. Yes. It speaks to the victim of the offence, who is the virtual complainant, albeit
Oh, I see.
the prosecuting authority is obviously the state.
Yes.
I see. So sometimes it's complainant and that means the same thing.
No.
The complainant is the police.
Yeah, the complainant is different. The complainant is the police officer who lays the charge against
all right.
So the virtual complainant is the victim.
The victim is the child.
In each case, the complainant appears, and that's a police officer.
Yes.
And the virtual complainant is the child who is remanded in absentia.
Yes, and that's the point. And that takes place, as I said, 20 out of 30 occasions when this matter was called. And sometimes a notice made by the court as to why. Like, for example, you've seen some cases they say transportation difficulties. If you look at 2401, at the top of page 66, you'll see virtual complainant absent, transportation difficulty. And you'll see it again below on 21st of February 2013, transportation difficulties, remanded in custody, and it's always in custody. And that's the way it went. Now, my lords, the reason I said the trial judge was you have to take the evidence in the round.
Why do you say you think it would have been better for him to have been brought to court on these occasions?
Oh, yes, my lady, certainly, because, my lady, the whole purpose of bringing the child to court is for the court to see the child. And if there's any problems, what happens in the magistrate's court is the child will be asked by the judicial officer, how are things? Are you okay? So that is an opportunity for the court to observe the child and seek the child's welfare. And that is why the child should have been brought to court. And oftentimes the practice is that the magistrate would make some informal inquiries of the child. Is everything okay? Etc. But to have a matter with a minor who's 9 years old, and for 20 out of 30 times they don't bring the child to court, and the magistrate simply adjourns and remands him in absentia, that, with respect, it's not just arbitrary; it's a complete failure. And you see, further to which, what is even of greater interest is, if I take you could you get page 66, my gosh? 66 with the extract now, okay? Myself complete. Yeah. If I take you, you will see that the magistrate, page 67, the magistrate asked for a suitability report. It's at 19, entry 9, it's at the top of page 68. You will see that it's on the 19th of May,
968?
968, yes. No, it's 971, beg your pardon. 971.
The 971?
Yes. And on the entry 190514, you will see that there's an entry where ready to proceed, suitability report outstanding. Now, that suitability report was outstanding. It started, if you go to page 970.
What is the suitability report? Sorry.
The suitability report, my lord, tells the court about the child's circumstances where he is being kept. So if you go to the entry on page 970, on the 7th of August 2013, you will see the court requests, line 5.
Are you sure about that? Because it looks as though it's something to do with the defendant.
No, my lord, if you look at the entry on this on the top of
request suitability report from St Michael's Boys Industrial School on Joshua. This is top of 970.
Oh, thank you.
That's correct. So you see, that suitability report was to gauge the interest and welfare of the minor. And what I want to show you is that the matter, since August 2013, that was ordered. The court asks for that, and the matter is completed. We look at 1905-2014. It's still outstanding. And what happens next? They determine the matter. The child is not being brought to court. The suitability report is not prepared, and they just determine the matter. Had the court been given the suitability report, it would have obviously alerted the court to the fact that the child was being kept in a place that was not conducive to his welfare and well-being. And that, we say, is again another safeguard in the system. Bringing him to court was one safeguard. Having the suitability report would have been another safeguard. The reports that were made to the Four Roads police station by the mother and the court officer, that would have been another safeguard. But all of this is left in a state of vacillation and abeyance, because the state does not tell us Well, what happened? And then I take you next to page 999. Now, this is the letter of reference to sentence from Dr. Sharp. And what I want to show the board is this. It says, this is the letter, and it begins by saying, thanks for agreeing to admit JM to an inpatient ward at the St. Anne's Hospital. Now, this is before the child is examined. So when the Court of Appeal says that, the trial judge was wrong to find that the child was wrongly sent to St. Anne's, an adult psychiatric institution, because there was a medical assessment and evaluation, we say no. The trial judge was perfectly entitled on the evidence to find that there was no real, genuine, and meaningful assessment. Can you put it in for me, the way you type out of the report after? Because there was an agreement to send it, and there was an agreement based on a conversation to send the child there. And if we look lower down, we are told, since his placement at St. Michael's, he was seen briefly by me in October 2014. This is October 2016, she's writing this. Interventions I recommended have fallen through. Living situation at St. Michael's is that boys are all sharing a makeshift dormitory. He's been physically abused by them and is unable to defend himself. As you know, children with Prader-Willi syndrome, in addition to overeating frequently, are intellectually challenged. This will be a temporary arrangement until the dormitory and other physical conditions at St. Michael's improve. And don't worry, construction work is already in progress. I mean, that's the tenor. So, my lords, the trial judge, on the basis of this, was entitled to find and make as a reasonable, irresistible inference that the child was being removed because he was being exploited and abused, and he was being removed to be put elsewhere because of that fact. Not because he was a psychiatric patient and it was pursuant to some genuine evaluation. No, it was a temporary stopgap measure because of the exploitation that was taking place. And what should have been a temporary measure turned out a year later to still be in place until we went to court on this matter on an emergency basis. A year later. To take a young child and for such a prolonged period and leave him there, given the content of this letter, is simply wrong. And then we come now to the admission paper, which is dated the 6th of October. The letter, I remind you, was dated the 4th. And I have to apologize. There's a lot in your record that is not legible. We did ask on numerous occasions, even at the High Court, to see if we could get more legible copies of the medical notes. And that is how it's been since the matter started, unfortunately.
Which page are you wanting?
I am now on page 1001. And I'll read for you.
It's quite legible, really.
Sorry?
It's fairly legible.
No, but that's what I'm happy to hear that. So essentially, it says, the undersigned has personally examined the child, and that he's made reasonable.
What you showed us in the mother's affidavit.
Yes, essentially, that's right. But what I ask you to notice is the bodily scars and all of the other things that are recorded there. None of that really speaks to a finding of psychiatric illness. I mean, if you have bodily scars consistent of burns and multiple scars about your chest, abdomen, arms, and face, and it's a child, who is coming from a position of vulnerability where he was being abused, that's not evidence for a psychiatric finding. There's no evidence. It's not to say it was self-inflicted. And then the second one is court officer has stated that he has been abused and has been a victim of aggression and torture. Home's supervisor also reiterates abuse and violent behavior against him. And the home supervisor, the name is put Laurette Lala, the court officer's name is put Keisha Sullivan. So the evidence of torture and abuse and bodily scars, how on earth could the trial judge be criticized for drawing as a reasonable inference that there really wasn't any psychiatric evaluation of this child?
But it isn't the psychiatric evaluation that he's suffering from Prader-Willi syndrome.
Well,
that's what the Court of Appeal said, that there's no doubt that that was the diagnosis, and the judge erred in not regarding, in taking the view that that didn't amount to psychiatric illness. It wasn't to do with the scarring, it was to do with that diagnosis.
yes. You see, my lady, the problem is that this form, if you it says, I've made reasonable inquiries, I've examined, to form a satisfactory opinion of his mental condition. I further certify, in my opinion, he is mentally ill, and in the interest of safety and protection about his between the husband. I mean, my lady, to equate, I don't think you have to be a doctor or have to be an expert to see that Prader-Willi, to equate Prader-Willi syndrome, which is a developmental issue, presents developmental issues. You can't equate that with mental illness.
It's not common sense. The Court of Appeal said that that's not, you need to be medically qualified, which the judge wasn't, but the experts were, to say whether it's proper to characterise it as a mental illness.
Well,
I don't think you can appeal to common sense on that.
Sure.
Point.
Yeah. Well, lady, we do rely on common sense, and we say that the judge's employment of a common sense was justified and cannot be faulted when one considers the documents together. Because one has to take this with the letter that precedes it. And the letter that precedes it evidences an agreement without any form of examination to admit the child. But I say, my Lord, but I say even further that a judge would be entitled to use their life experience and knowledge and to say, well, look, a genetic disorder that presents developmental difficulties is not to be equated with a mental illness that should lead to a child being placed in a mental asylum. St. Anne's is what we call, in local parlance, the mad house. It's the mad house. It's for mad people. And adults, not children.
What's the legal significance of this point? What difference does it make?
Well, Lord, it's important because on the issue of vindicatory damages, my submission is when one takes the evidence in the round, on the totality of it, there is ample evidence to cause sufficient outrage to have justified the award of vindicatory damages and for the court to want to send a signal, as it were. So and also to say that insofar as this formed part of the Court of Appeal's reasoning for reducing even the compensatory damages, that's wrong. I take you next to page 1005. And this is the report from, this is a social history report, and I take you to page 1006. This is at 1006.
Certainly, in 1005 at the bottom, the report suggests that the removal to St. Anne's was simply on a temporary basis until the construction works, I imagine, in St. Michael's were completed.
Correct. Correct. Correct, my lord. It says at the bottom of page 1005 that it was recommended that it be transferred on a temporary basis, or at least under the physical conditions at St. Michael's improved. His interests are listening to music, viewing wrestling videos, going to school. He had one experience of smoking marijuana whilst at St. Michael's, and he later confessed to the mother that he was given the drug by another resident. He'd never been in trouble with the law, and they said during the interview he displayed a pleasant attitude, appeared to be rational in thought, but his responses were restricted to 3-word sentences, and he loved his mother and wishes to go home. I then take you now to page 1008. And the second to last paragraph, says medical staff instituted treatment with oral medication and behavioral modification techniques. Despite this, Mr. M continued urinating and defecating in the dorm, cursing and verbally assaulting staff. He has been placed in the seclusion room on numerous occasions for aforementioned behavior. On numerous occasions. Now, I stress that numerous occasions because that is not necessarily consistent with what is actually set out in the actual medical records. I take you next to page 1012. And you will see at the bottom of page 12, you will see 2 instances recorded where on the 16th of December 2016 and the 17th of January 2017, he was put in a seclusion room. We are not told for how long, but we know that there were physical restraints used. And you'll see that at the bottom right-hand corner of page 1012. Are you with me, Mellors?
Yeah.
1012 at the bottom right-hand corner. Just 2 instances. 2 instances. But we know that the report said numerous occasions he was placed in the seclusion room. And then I take you next to 1014, which is the page just beneath that. At page 1014, this is the case summary. And we are told, this is where we are told at page 1014, in the second paragraph, 4 lines up from the bottom, he was deemed beyond control and remanded to St. Michael's home, and then committed in June 2014. Now that's totally wrong. But if that's the official recorded information, and that's why the trial judge said they were treating...
What do you mean it's totally wrong?
Well, because he was never deemed to be beyond control. He was a victim. He was never an offender. There was no such order of finding. Joshua was, the child was a victim, not an offender.
But those 2 things aren't inconsistent with each other in this case.
Beg your pardon? Sorry.
I'm not sure I understand the point that you're making about whether he was deemed to be on control. Is that a legal...
It is, Millie. It's an order under the Children's Act. It's an order that can be made by the court. And there was no... And the trial judge highlights this and said, look, it's clear that they were treating this child as though he was an offender. That's why they remanded him, they use language like remanded in custody and so on. And the trial judge this is the evidence, there's ample evidence for her to say that. When we saw the transcript of the official record from the magistrate's court, the language is consistent with a youth offender and not a victim. And this here confirms that, because the records that they have say he was deemed to be beyond control and remanded and then committed.
What is the statutory provision that deals with a child being beyond control?
It's in the, my friend Mr. Strang will tried to assist me with it, but it's in the Old Children's Act.
Because this could be a significant point
Yes.
if the authorities were treating him as someone put in the system for a reason totally different from that.
Indeed.
Which was actually the case.
Indeed, my lord. Can I come back to it?
Yes, well, I think it's quite important that you vouch that.
That's why I took that. That's why I took.
But your answer to Lady Rose was that deemed beyond control is a legal term within the statute.
At the top of the thing, we see it being referenced to being committed for being beyond control, in quotes.
It's section 44(4) of the Old Act, which you will find on page 2308. Subsection 4 is it? Yes.
Yes, so it's a provision at the initiative of the person, the parent or the guardian of the child.
Yes.
Proves that they are unable to control the child.
That's correct.
But that provision should result in a child going to an orphanage.
Correct.
Not an offender's.
No, which is what St. Michael's and YTC and so on.
Yes.
That's the point. So that's why we say.
Well, that's not treating him as an offender, because if he's deemed beyond control, he's being treated as someone who the parent can't control. And certainly there is evidence in this case that the mother couldn't control.
Well, my lord, I think what beyond control, yes, my lord, what beyond control means there is a child who is a normal child whose behavior is such that the parents cannot control the child.
Why does it make any difference what the reason is?
Well,
the inability to control the child. If the parent can't control the child.
Well, with respect, it does make a difference, because if you have an unruly, indisciplined child who's normal and capable of rational thought, in full possession of their mental faculties, then that's a far cry from a child who has a genetic disorder and may not be and has developmental difficulties.
As far as the parent is concerned.
It's the same as, yes, from the parent's perspective, yes, but from the child's perspective and how the law will respond and view the child, it's different, because if a child, a normal child, is beyond control, then that child will have to be treated completely differently to a child who has a genetic disorder that somehow impairs and compromises his mental faculties, and will have to therefore need treatment and rehabilitation.
I can see that difference, but I can't see how it makes any difference to section 4.4.
Well, the
real point is that he should have been sent to an orphanage, isn't it?
That's the point, yes.
The point, really.
Yeah.
Yes, but it isn't that they were treating him as an offender. They may have been wrongly treating him as someone to whom section 44(4) applied, but your point is, even so, he shouldn't have been in an industrial school or a psychiatric institution.
Correct.
Whatever.
Yes.
But I don't see how this vouches him being treated as an offender.
No.
Well, it's not this by itself, but the language of the remanding and committing and so on. But I shan't press the point. What I will say is that.
Well, that's the point, isn't it? You might say that the overall flavour is that this person is an offender because of the usage of remand.
Well, that's what the trial judge found.
Yeah.
And I said she was justified.
I don't think you can place too much weight on deemed beyond control, because that's neutral, actually, for these purposes.
I mean, it might be a bit legalistic. The short point is there was no order deeming the child, there was no order made deeming the child as beyond control, there was no what we call a beyond control order made against this child.
Right.
And that has legal consequences. And this child was sent to an institution which was outside his age bracket. He was too young to be sent to the institution that he was sent to. He should have been sent to an orphanage. So I next go to page 1015. And this is the 1015. We have his medical history. They start, and they tell us in 2013 he was diagnosed with Prader-Willi syndrome, a rare congenital disorder caused especially by the absence of certain genes normally present on the copy of chromosome 15. The condition is characterized by learning difficulties, growth abnormalities, poor muscle tone, sleep disorders, insatiable appetite, obsessive eating. Both males and females have underdeveloped genitals and are short in stature. Behavioral problems are common in patients, including temper outbursts, stubbornness, and compulsive behaviors. I pause there. That is precisely what Joshua is exhibiting, but it's a corollary of the disorder that he has, and it shouldn't be held against him.
You keep saying this, but he still has to be, somebody still has to deal with him.
Of course.
Whether it's his fault or not.
Yes, I agree with that. And this is precisely the point I'm on. This is how they were supposed to deal with him, if we read on. It says, after receiving the diagnosis, an intensive care plan was developed and implemented. And Joshua has benefited from recreational therapy sessions, dietary plan, exercise plan, occupational therapy, speech and language therapy, medical evaluation, audiological evaluation, psychological assessment. All reports in these interventions suggest that Joshua shows potential for learning, and all recommended that the interventions continue in unison. So there was a care plan to meet the disease, to rehabilitate him. He wasn't, not that it's irredeemable. At 1016, we are told in the second paragraph, Mr. Mills noted there were suspicions that he was being sexually abused at the home. Those concerns were exacerbated by reports of him acting sexually inappropriate among peers and caregivers. One record from the home cited that he was heard making sexually explicit noises and mimicking sex acts. The concerns were brought to the fore when he communicated.
Yes, we can see what's said there.
Okay, fair.
But you have a characterization of his experience in St. Michael's from the Court of Appeal as a living hell. So I think the court is alive from its reading to the treatment that this boy suffered at St. Michael's.
Much obliged, Barry, much obliged. And I'll move on from this report, except to say that when one reads it, it supports the point we were making, that look, it's treatable, and this is why I said the beyond control aspect. It was not a normal child who was beyond control in terms of being of bad behavior, making a conscious decision to behave badly. This was a child who had a disease, a disorder, and this was the treatment plan for it. Can I next go to page 1069. Now, I'll make the point briefly, but in paragraphs 8 and 9...
What are we looking at here?
1069, my lord, this is the affidavit of Jacqueline Wilson, Permanent Secretary in the Office of the Prime Minister. Johnson, Jacqueline Johnson. My lord, I said this also goes to vindicatory damages. The conduct of the defendants in this matter left a lot to be desired. There was a virtual catfight amongst them, where the state sought to remove itself from the litigation, saying they're not to be blamed for anything, and they have no role and responsibility. And we spent an awful lot of time with legal arguments, joining no less than 5 parties, and to try and legally wrangle it out to see, well, who is responsible. And this is what the state's position was. The permanent secretary says the home is owned by the Anglican diocese and the board, whose members are appointed by the diocese. The manager is responsible for the day-to-day running of the school and has sole responsibility for daily care, supervision of the children who reside there. The board makes its own rules and internal policies as it relates to children and care, subject to the approval of the Children's Authority. The ministry does not get involved in these aspects of running the institution. I recall seeing the claimant with all the other boys, on my visit as Deputy Permanent Secretary to a vacation camp held for the boys. I noticed the child was overweight and somewhat slow. I was a member of the group and no further information was forthcoming on the child. Well, if no further information was forthcoming, did you ask?
Well, it's an attempt to say that the institution itself is responsible, not the state. Now, that's water under the bridge.
It is.
Because the state's attempt to deny responsibility has not been accepted, and the state does not now challenge that finding.
Indeed. And I'm grateful, my Lord. The submission I make, though, my Lord, is this. That, too, is an aspect of the case that would lend itself to an award of vindicatory damages. That's the submission I make. For the state, the conduct of the state in the matter towards your appellant in this matter by saying, look, to wash its hands clean of the matter and simply say, well, tough luck, this has nothing to do with us. In light of the statutory mandate and the role of the state, I said that just was not on. At page 1087, well, we can read that at the top of 1087.
What are we looking at now?
Sorry?
What is this?
What's this document?
Oh, sorry. At 1087, this document is the affidavit of Alana Buchun, who is the social worker who works with the Children's Authority. And this is a report.
A report she made?
Sorry, Milo?
A report that individual made?
Yes. The front page is a 1084, if you'd like to have a look at it. It's a 1084. And essentially, at 1087, we say this is confirmation of the rape. The first paragraph at the top.
Was this an incident that the Court of Appeal awarded damages for or not?
They did. They did. Compensatory, yes. And then if I take you next to page 1091, you will see again another instance of sexual assault. I believe the same one, isn't it? Same one? Well, it's further evidence of the same sexual assault, but we now know the age of the perpetrator.
Where's this?
At page 1091. So we know the perpetrator was a 26-year-old male patient at the St. Anne's Hospital, and one might say in parenthesis, a 26-year-old psychiatric patient. And then at 1093, we see in the second paragraph of 1093, we see a further comment about the sexual abuse and about how his scars were healing on his trunk and arms and what have you. And they say on the background of prior sexual victimization and exhibited sexualized behavior, Joshua has likely experienced further emotional trauma as a result of the sexual assault on the 2nd of October, ongoing behavioral therapy is strongly recommended. No evidence of that having taken place. I reference this because the Court of Appeal said the trial judge could not have found that there was psychological damage when he was placed in the seclusion room and as a result of the treatment meted out to him. And we said that's a reasonable inference. You didn't need, yes, she didn't have a medical evidence, but she had this evidence. And this is sufficient to support her finding that the child would have suffered psychological harm.
Well, as a result of the abuse and the sexual...
as a result of...
And as a result of the further assault in October.
Yes.
It's not making any comment about the consequences of seclusion.
No. Yeah. No, but I'll come to seclusion. So I take you next to at page 1115. And this is the affidavit of Jomo Thomas, who is attached to the Children's Authority. He's a service associate. And at paragraph 10 of his affidavit, he says, to the best of my knowledge, he's talking about a sentence transfer, and he says, to the best of my knowledge and belief, the decision was taken by the management of St. Michael's to transfer Joshua to St. Anne's. This was done without the knowledge or involvement of the authority, which was only made aware of the relocation of the child to St. Anne's after it was achieved. Well, if you weren't consulted, and you should have been, and if you became aware after, what did you do about it? My lords, there was a court order for this child to be remanded to a specific institution. People cannot take it upon themselves to relocate the child without any variation to the court order and without reference to the court itself. No one bothered to make an application to the court to give evidence, provide a report and justification, to say to the magistrate who made the order, we want a variation of this order for the child to be placed in a psychiatric institution for mentally insane people. No one did that. And that's a serious matter, again, when it comes to considering the award of vindicatory damages.
But had the order to be taken to the Child Support Centre was made, I think, on the 23rd of October.
Yes. But
when was he transferred?
To St. Anne's?
To St. Anne's.
Long before that, my lady.
Yes, so the transfer to St. Anne's wasn't in breach of the order that you showed us at page 55.
The order about which the order that I'm referring to is the order that the magistrate would have made. Sorry? The order that the magistrate, not the High Court judge.
The order committing him to St. Michael's?
Correct, yes.
It's a matter of debate, though, whether it was worse, which one was worse, isn't it?
Well, yeah, that's true. But my short point is, as a matter of the rule of law, if there's a court order remanding a child to a specific institution, i.e. St. Michael's, people cannot simply take it upon themselves, without reference to the court, to seek a variation of that order, place him in a mental asylum.
I hesitate to interrupt. Can I just point out that page 802 of the Court of Appeal's judgment, in the first paragraph at the top, it is recorded that this was an admission under the Mental Health Act. And so it may not be quite as simple as saying it was necessary to go back to the court for a variation of the court order, because it was not something done simply because St. Michael's wished it to be done.
But was there a court order, a variation of the court order?
No, I don't believe there was, but there was.
Well, you can't just admit under the Mental Health Act in breach of a court order without going to the court, can you?
My Lord, I wasn't going that far. I was just pointing out that it was a procedure that was taken under the Mental Health Act. That was all.
Well, no doubt you can point to us the documents that vouch that procedure.
I'm advised. So, my Lord, but the point is, to the extent that the Children's Authority would have should have been informed and was not informed, to the extent that the court should have been asked to vary its order and justification provided, and to the extent that neither of those things were done, and to the extent that the Children's Authority did subsequently find out, but did nothing about it. All of this shows a complete, colossal failure on the part of the state. All of the mechanisms for safeguarding the child's welfare were just completely falling apart. I mean, these are institutions that are well-funded, with large staff, with qualified people. And then at 11:16, I want you to note that 11:16, paragraph 18, still on the same affidavit from Mr. Thomas, this is what he says. He says, on February 2nd, 2017, he conducted another visit to St. Anne's Psychiatric Hospital to see the minor. At that visit, I met with the nurse, who indicated to me that on the 27th of January, the child was transferred to Ward 2, which accommodates more acute patients. I was further advised that he was being administered Respondent and what have you and so on. But not Ward 2 has a certain local ring to it back home. But to upgrade the child like that, without any real reasoning or evidence to justify it.
Well, we know he was upgraded, but this doesn't tell us why he was upgraded.
Yes,
to say that there was no reasoning is not an inference one can take from this paragraph.
Well, what I will say is this: the evidence. This is the Children's Authority giving this evidence, and the evidence as to the reasoning could have only come from the state. And to the extent that they remained silent and didn't comply with the duty to make full and frank disclosure on these matters, we say that the legal implication is that adverse inferences should be drawn against them and in favor of the appellant.
Why would they move him to Ward 2 if there wasn't a reason to do so?
Well, maybe for the same reason that they put him in St. Anne's in the first place, perhaps, without any good reason, we say. But the point is, it's not for the minor to speculatively answer that question when the evidence is in the bosom of the state. And the principles that operate in constitutional law is that once we have filed a claim, then they're duty bound to make full and frank disclosure of all material evidence. The onus was on them to justify it. I take you next to what page? At page 1123, and this is now at 1123, this is the affidavit of Safia Noel, the director of the Children's Authority. It starts at 1120. And at paragraph 9 on 1123, she sets forth, because she's trying to take the Children's Authority, of which she's the director, out from the liability equation. So everyone is just taking themselves out. The state is taking itself out. She says, look, since proclamation, we've been advising the line ministry about the need for specialized facilities for children with mental health and other challenges, including but not limited to, and she sets forth a long list. And when you read it, you will see that the state has been aware of the need to have, the need to cater for this problem. But thus far, what the Children's Authority is saying is that they've just been ignoring it. And children, as a result of that, are therefore ending up being placed in institutions that are totally inappropriate and are conducive for their exploitation. And that, we say, rings hard on vindicatory damages. And then we go to 14 and 15. Yes, 14, 15, where you will see that evidence of suicidal tendencies creeping in on the part of the minor. 14.
Paragraph.
Oh, paragraph 10, sorry, beg your pardon.
Of what?
This is paragraph 10 of the affidavit of Vandana Sivsanka, clinical psychologist. It starts at page 1412, and we are on 1415. And she says, over the past few weeks, he's been uttering notions suggestive of suicidal ideation at least once weekly. On several occasions, he has stated that he wants to die. He has stated that he prefers to die than to do his exercises. He's made gestures. He would take a bedsheet to hang himself, place his hand...
Where is he at this stage? What is... we've just jumped into this, but what point in the chronology are you talking about?
He is now out of St Anne's at this stage.
Yes.
Out of St Anne's?
Yes.
Yes, I mean these are events after his transfer out of St Anne's.
Correct.
And we see that in paragraph 4 at the CSC. He's benefiting from certain services, and this is behaviour once he is located in an appropriate place.
Yes.
Yes.
Yes, indeed. I mean, what we say about that is this is evidence of how badly damaged the child was.
Yes.
So this is when he is in the child support center?
Yes. And we say this is evidence of how the extent of the damage to the child. And then I take you next to 1902. And at 1902, this is the evidence of Alison Jacobs Joseph, the welfare officer at the school, and it starts at page 1900, and we are in 1902. And at paragraph 5 on 1902, she says, he was remanded to St. Michael's from the Superior Magistrates Court. The decision was made to accept him on the recommendation. Case history, sent to several homes, and this is where we're told he spent one night in the police station, another night at St. Michael's Remand Facility at the Youth Training Center, which is essentially, like a youth prison. And then we are told that he was remanded in St. Michael's because the new place willing to accept him in spite of him being below the minimum age of children at that school.
We're well aware of that. We're well aware that this was a child who was 9 at a time that he was sent.
Much obliged.
And what's abundantly clear is that the state had nowhere else apparently to deal with him, and that is part of your complaint.
It is indeed, my lord. It is indeed, my lord. Now, my lord, at 1940, 1940, you will see this is evidence, contemporaneous evidence, when he was burnt with a lighter. These boys stood over him and basically lit him up. And 4 years after this incident, no one from the state can tell us, well, what's the outcome of a single police report, a single police investigation? Has the member of staff who beat the child been fired? Disciplinary proceedings, suspended? Nothing. And in this case, at the bottom of page 1940, the child says, X, who sleeps close to him, was questioned as to what happened. He was hesitant to say at first, so I brought him in, and then he said that, look, these boys burnt him with an insect spray and lighter, and they also tried to burn another boy, and he was badly burnt. And then if you go to page 1942, the other child says, well, I was lying on my bed. I saw this. I saw him with a lighter.
Well, Mr. Ramlogan, we are well aware of this appalling incident, and I don't think we will gain benefit from looking at any more detail. We know that this incident happened, it was terrible, and you as I say, you have in your favour a finding from the Court of Appeal that his time in St Michael's was a living hell.
I'm much obliged, Brad.
What more do you need in that regard?
Can I move on then? Well, what we say is this. We say on the issue of vindicatory damages, at our written case, which you'll find at page 2229, we have cited the well-known case from the board of Allain, and in Allain, there was no dispute that vindicatory damages could in fact be awarded for institutional sloth and inertia.
Yes. That seems clear.
And we also have cited at page 2230 additional judgments from the courts in Trinidad to show that vindicatory damages have been awarded in cases where there is no finding of malafides. None of these cases we've cited at pages 2229 and 2230 in which vindicatory damages were awarded was based on a finding of intentional hostile conduct or malafides. None of them. They were based on maladministration that rose to a certain level and had certain serious, caused serious prejudice and serious consequences. We say the Court of Appeal therefore erred in finding that if Joshua was fully compensated in compensatory damages, there was no legal basis or justification to make an additional award of vindicatory damages.
Well, what was, though, the Court of Appeal's reasoning? You need to show us that the Court of Appeal's reasoning in overturning the award of vindicatory damages is wrong in some way. So
yes,
at some point.
Certainly, yes, I can do so. Lady, if I could take you to 842. It starts at 878, sorry. It's 878. At paragraph 196, the Court of Appeal says, when the circumstances giving rise to the breaches in this case are examined, it is clear that they did not occur as a result of malice on the part of anyone, ill will, or deliberate behavior or systematic ill treatment. Rather, they occurred as a result of institutional inertia and were more the result of omissions on the part of the authorities that were responsible for ensuring that they did not occur, rather than part of any deliberate pattern or conduct. So that was the reasoning of the Court of Appeal for reversing the award of vindicatory damage, and we say that that's just plainly wrong in law. And the finding of cruel and unusual punishment, we say that to the extent, we say that that might not be relevant to the issue of compensatory damages, but it's certainly relevant to the issue of vindicatory damages. And we say that the evidence taken in the round, it rose to the level where it would have violated the minimum level of, attained the minimum level of severity for there to be the declaration as to.
Probably the end of 198 might be the best point, where it says, the Court of Appeal said, the institutional inertia as opposed to deliberate inaction or malice or other deliberate conduct could not be a circumstance that could give rise to an award of vindicatory damages.
It's not a case of the court saying, well, we're awarding quite high compensatory damages, and in the round, vindicatory damages isn't needed. They seem to be saying that because it's an inertia claim, a circumstance, it is not competent to award vindicatory damage, and that flies in the teeth of a lane.
Yes, it's an error of law on the Court of Appeal's part.
Yes.
That's the point. Well, can I just, there's a case we emailed, we sent this morning.
Can I just before we leave that point, I'm sorry to interrupt. Is there any authority that would indicate that vindicatory damages are only available for malicious or deliberate conduct?
No, there is no such authority. No such authority, my lord.
No, you're moving on
Yes,
to...
I'm moving on to the case we sent this morning. It's a simple principle. It's Boyard versus Belgium. And if I can take you to...
I'm not sure whether I've got that or not.
It is in the bundle.
Oh, is it?
It's been added. It's been added this morning to the authority.
Right.
But your point here is that under Article 3, cruel and unusual treatment isn't necessarily cruel and unusual treatment by representatives of the state, but if someone is in effect in state detention and others treat him in a certain way and which amount to cruel and unusual treatment, the state is answerable under Article 3 for that.
Correct. And yes, and the second point is the child in that case was 17 years old, and for one single slap by a police officer.
Well, that's a pretty extreme case. I know the Boyer case, and some people might think it was taking the concept beyond its proper limits.
Fair enough.
Or at least to the extremes of those limits.
It is.
But there is ample Strasbourg jurisprudence which would support the view that if you are in state detention and your fellow inmates treat you in such a way, that is a failure by the state of its positive obligation to protect you from that behaviour.
Indeed.
I think that's the point you're citing.
It is, my lord. And my lord,
Can you just help with how that fits into the Constitution? I mean, this is probably well established, but what the constitutional provision actually says is that Parliament may not impose or authorise the imposition.
yes, my lord.
I mean, obviously Parliament is not imposing or authorising what happened.
No, my lord, the way the law that has been developed is that in practical administration on the part of the state, if there is treatment or conduct that attains, crosses the threshold of the minimum level of severity, it can result in a declaration for cruel and unusual, a breach of the right not to be subjected to cruel and unusual punishment. So it's not restricted, it's not viewed restrictively as though Parliament may not enact legislation to authorize it, but it's just that the state cannot, dispense conduct that would cross that threshold.
If at some point you could just give the name and reference to the best authority for that proposition, it would be helpful.
Certainly.
Because looking at the plain words of the Constitution, you might say that the breach is a breach of security of person, but it is a breach of such seriousness that it can be categorised as cruel and unusual treatment.
Yes.
So it's a 4B breach.
Yes.
Yes.
Certainly.
In its terms, and it's the practice of the courts to include a declaration that it amounts to cruel and unusual treatment.
My lord, the final point I make before...
Sorry.
No, 4B is I think is a security.
No, that's protection of law, actually. 4A. Yeah.
4A is security person. I do apologise, and you're characterising that breach as being cruel and unusual.
Yes.
Yeah, but if there is authority to support how it's done, then like Lord Leggett, I would like to see it.
My learned friend, Mr. Strang, who's followed me, will speak to the issue briefly. But before I take my seat, one final point.
Then, are you saying that it's a... I thought that in answer to my Lord Leggett's question, you were saying that 5.2b had been interpreted that it wasn't simply Parliament imposing it.
That's also correct. Yes, I did see that.
But is that all? Is that? But then you seem to be saying that some of the rights in Section 4 have been interpreted as.
Well, Milady, some of the rights in Section 4 do have a somewhat radiating effect on the other rights. So yes, as my Lord says, the right to security of the person, for example, can in fact, if it's breached, it could lean over, as it were, and lead to cruel and unusual punishment. But the short point is that insofar as that is contained in the Constitution, one can obtain a declaration that your right not to be subjected to cruel and unusual punishment has been breached. The final point I made before I hand over to my learned friend, Mr. Strang, is this. Whatever the test and the circumstance, it has to be flexible to cater for the fact that this is a minor, so that a lot of the learning on cruel and unusual punishment and about the minimum level of severity, whatever applies to an adult, will obviously have to be catered for that you're dealing with a minor in this case. Lord, can I pass over to my learned friend, Mr. Strang? I'm obliged.
Mr. Ramlogan, thank you very much.
Keep it close.
Mr. Strang.
Just dealing with that first question about Section 5. I think the position is, but I'll get an authority over lunch if I may, but I think the position is that the Section 5 rights are treated as enforceable on their own terms, but by way of informing the Section 4 rights.
My learned friend is right. I think the authority is a case called Thornhill. Certainly it was Lord Diplock. And if it wasn't that case, it was one of the cases referred to in Thornhill.
They're treated as, yes,
it's treated as explanatory of
Section 4.
Section 4.
Well, that's how I would read the provisions. That,
With respect, my Lord is correct, but I think Lord Diplock put it rather more succinctly than I have. And I think it was in the case of Thornhill. But
yes, well, that makes sense, because Section 4 confers the rights. Section 5 has a general provision stating that laws can't abrogate those rights, and then you get further specification which gives colour to what those rights are.
As I recall, specification was exactly the word that Lord Diplock used, but yes. My Lord, I'll check over the lunch adjournment. I think
I have a memory of that. Thank you. Thank you.
Just while we're on that point, I would be grateful for just a bit of help on the relationship between, well, understanding what 4A, how we read 4A. We've got the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. So the question I've got is whether except by due process of law is qualifying the right to the security of the person. Because I can't find any direct reference to that in either of the judgments below. They seem to treat the security of the person as if it was freestanding.
Yes, my Lord, and that's my submission too. I don't bring any further authorities. I adopt.
It can't be an absolute right to security of the person, because people are handcuffed or have medicine administered to them if they need it without their consent, as long as it's by due process of law.
Here we are in the care of the state, and I suppose I would put it in that way. But any breach of JM's security of the person while he's in the care of the state is a breach of the state's duty to take care of him. So that can be placed under the Section 4A right to security of the person.
But I think what you're being asked is that subject to the exception of whether it's done by due process of law?
Well, just as a matter of construction, it doesn't say that the right is not to be deprived of life, liberty, security of the person, etc., except by due process of law. It doesn't simply say that. It says the person has those rights to life, liberty, security, and the right not to be deprived of them except by due process of law, which suggests that they are additional.
Yes, I'm not sure I could give a complete answer to every circumstance, but I'd say in this circumstance, while JM was in the care of the state and his security of the person was infringed, his right to security of the person was also infringed.
Yeah.
I say that's sufficient to answer the question for the present case.
My Lord, if it helps, there's actually a reference to Thornhill at page 361 of the bundle, paragraph 77 of the judge's judgment, which confirms both my recollection and your articulation of what
377.
361,
361, sorry.
paragraph 77. Section 528H, spell out in greater detail what is included in the expression due process of law to which the appellant was entitled, etc.
Yes.
Forgive me for interrupting, but I think, my Lord, I am remembering the correct case at any rate, and we'll provide a copy after the lunch, Judge.
Yes, I knew I'd seen a reference to the Thornhill case, but thank you for that.
Well, my lords and my lady, my submissions concern the Court of Appeal's errors in interfering with the judge's assessment of compensatory damages. And I'd like to develop 2 points. First, concerning the period of compensation. And that point is as follows. The Court of Appeal set aside the judge's award of compensation on a per diem basis for the entire period of JM's placement at St. Michael's, which was the first institution. And it said that daily compensation should only be for the period of the breach of JM's right to protection of the law, Section 4B right, which it said began in May 2015. And I say that was a bad reason for interfering.
That was the date on which the new legislation...
The new act came in, yes, my lady. That was a bad reason for interfering because both the Court of Appeal and the judge found that JM's right to security of the person, that's the Section 4A right, had been breached for the entire period. And
But in the case of the Court of Appeal, unlike the judge, they gave separate compensation for security of the person.
That's right, my lord.
Yes.
And I'm arguing for restoration of the judge's awards in toto. Except that means giving up the separate awards for security.
But in any event, was the detention of JM in the period between June 2014 and so 2012 and September 2012 and June 2014, was that not a breach of the his right to protection of the law?
Well, I say it was, yes, my lord, and I will develop that point too briefly on the Court of Appeal's own findings.
If that is right, then the breach of security can stand independently.
Well, if you're offering to increase the judge's award,
I'm not saying I'm offering to do anything, but I'm just trying to look at it logically.
Yes.
I mean, if he was deprived of the protection of the law from September 2012, then that would be a full justification for the per diem throughout.
yes, I say both justify per diem throughout.
Yes.
But I'm starting with the security of the person point, because on the Court of Appeal's findings, just as on the judges, the continuous breach of the security of the person equally justified a per diem award. So that's slightly different from how my learned senior put it at the outset. Really what I'm developing is the points at paragraph 8.3 of our written case, that's page 2224, the security of the person point. And the second point is on the differential between St. Anne's and St. Michael's. I say the Court of Appeal didn't give a good reason for setting aside the judge's award of a higher daily rate for St. Anne's. It merely substituted its own assessment for her assessment, and that it was not permitted to do. So first, the security of the person, which is protected by Section 4A. The Court of Appeal, just as the judge did, found that that right had been breached at St. Michael's from the outset. And the judge's judgment begins at, the section of the judge's judgment begins at page 366 and paragraph 86. So you'll see there that she's addressing Section 4A, security of the person. And she goes through her findings as to the facts, which are uncontentious, until her finding as to the breach, which is a paragraph 131, page 379. So the placement at St Michael's and St Anne's amounted to a breach of section 4A. We know that she's talking about the right to the security of the person because that was her heading at the start of this section.
So that is because of the attacks on him and such like, rather than the deprivation of liberty as such?
Yes.
Yes.
Perhaps it's right to say it's not really deprivation of liberty as opposed to... it's not really a deprivation of liberty case per se, because JM was always going to be in the care of the state.
Yes.
It's really about the conditions in which he was placed.
Yes.
And the fact that he was placed in harm's way.
And the security of the person includes not only the individual physical attacks, but the fact that he lived in a state of permanent fear.
Yes, my lord, you're ahead of me, because that's where I'm going to take you now in the Court of Appeal's findings. Yes. So the Court of Appeal's findings begin at page 837. And that's paragraph 71. So frequency and severity of the abuse contributed both to actual harm and the likelihood of constant fear of such harm. This would be sufficient to establish a breach of the right. And there's more at 72. Yes, breached from inception and continued to be breached throughout his stay. And then there's more at paragraph 80, at the bottom of the page, after the list of incidents, very last sentence, his security was constantly at risk. And over the page, this is where my Lord Hodge has already referred to this finding about the living hell, but I also draw attention to the fact that the Court of Appeal says one doesn't need to speculate that if there were these documented attacks, there would have been others less apparent in their effects, coupled with the constant fear of such attacks. And then I also draw your attention to paragraph 82. Paragraph 81, sorry. Yeah, we've had paragraph 81, I'm sorry. Yes, 82. JM, there's sufficient evidence to justify a finding of an environment of insecurity with sufficiently regular but unpredictable serious attacks to justify an inference that someone, especially a young child, would have been living in a constant fear. They say the paragraph ends saying St Anne's, but it's clear that we're still talking about St Michael's here. St Anne's is a mistake there. Paragraph 83, breached over the entire period. Perhaps I could just ask your lordships and your ladyships to just read the whole of paragraph 83, because I will come back to that on another point. On the protection of the law point. So as for these findings, though, there are three important elements. First, the breach was from the very beginning and covered the entire period.
This is for security of the person?
Security of the person, yes. From the very beginning, covered the entire period. Secondly, it was continuous. JM was in constant danger and constant fear. And third, the documented attacks on him were not the only instances of harm, and there were likely to have been other unrecorded attacks. But despite those findings, the Court of Appeal set aside the award of daily compensation for the entire period. It substituted a daily award beginning only in May 2015 which, as my lady Rose said, was the time of entry into the force of the new Act. So we see that at page 805.
So this is just an internal incoherence
Yes,
in the judgment. I mean, they're saying there was a breach from day one, but actually, when they come round to quantifying the damages, there's a lacuna that they've left.
Yes, that's what I say. Yes, my lord, yes.
Yes.
So which was the reference you just gave? Sorry, I didn't catch it.
But page 805 at Roman 2, this was their reason for...
This is the summary, was it?
It's a summary, yes.
Yes.
This helps summarise because this is where they differ with the judge over the protection of the law, saying that the breach of protection of the law begins only in May 2015. And then that makes its way into the quantification of damages, page 872, paragraphs 177 and 179 over the page.
Sorry, what page are we on?
So this is page 872 and 873.
Yes, so your position is whether or not the Court of Appeal was right about the protection of law point, and I think your position is they were not right.
Yes.
But in any event, on their own findings, there was a breach of the constitutional rights in St Michael's from day one.
And ample justification for a per diem award on their findings.
As I read paragraph 12.2, they're addressing deprivation of liberty rather than, or unlawful detention, rather than
Yes.
JM's treatment.
Yes.
And as I said before, that's a source of confusion here because...
You're saying they carried that over impermissibly into the security of the
Yes.
person?
Yes, I see.
And because JM was always going to be in the care of the state, and the real issue is, that the real complaint is the conditions in which he was kept and the harm he suffered as a result of his condition, of the unsuitable accommodation.
But they were concerned that these things were all overlapping
Yes.
and that there mustn't be double recovery.
Yes, and
But was the security of persons, that was the damages that they awarded for that were not the per diem damages, they were the specific damages for the individual incidents. But you're saying that insofar as the overall outcome did not award him any damages for a period
first 2.5
for
years.
the first 2.5 years.
Apart from
That must
3
be wrong after their finding, because
Yes.
to have awarded him a per diem rate for that breach would not have actually led to double recovery with any of the other breaches, but where that would leave the compensation for the individual incidents is a different question.
I say, my lady, the best thing is to restore the judge's award.
The individual incidents, anyway, even if there was compensation for them, that left out what was happening on every other day when there wasn't a specific incident.
That's my other point.
There's no double counting now.
Yes. And there's no evidence that, there's no suggestion in the judge's judgment that she is increasing her daily award because she finds a breach of 4A as well as 4B. She's just assessing JM's suffering.
Yeah. But you're not asking us to increase the award.
No.
Because there could be a logical point.
It could be, yes. So where was I? So that's, yes, and so we see how this, the Court of Appeal then ends up awarding a per diem only from May 2015 and making, in respect of the right to security of the person, only 8 distinct awards. And the incidents that they cover are paragraph 194, which is page 877. And as I said just now, only 3 of those cover the period before May 2015. The incidents at Roman 4, although they begin with the change of management in early 2015, those incidents are in the latter part of 2015 or later. So, yes, and I'm saying that the Court of Appeal was wrong to decide that only the 4B breach could justify a per diem award. And I can illustrate that with the Court of Appeal's own reasoning.
Sorry, the 4B breach.
Being the protection of the law. The Court of Appeal said a per diem award was only justified.
What were the facts that led to the award of damages for the breach of protection of the law?
That's where I'm going now, my lady, because I say they equally apply to security of the person and the 4A breach. So paragraph 158 is at page 867. So this is the Court of Appeal's reasoning on a per diem award for breach of the right to protection of the law.
Sorry, I missed the paragraph.
Paragraph 158,
866.
page 867.
Sorry, thank you.
866. 866.
Sorry, yes, so you can, if you want to see the beginning of the reasoning.
No, it's fine.
It's 866, they start discussing protection of law.
And then
Yeah.
over the page at 158, it's discussing the reasons that lead to a per diem award. And I say they equally apply to, I mean, the reasons here are
But
wholly...
the award for breach of protection of the law was only from 18th of May 2015 onwards.
Yes. But the reasoning for it, the reasoning for saying a per diem is justified, is wholly consonant with the Court of Appeal's findings on the other breach, the right to security of the person. And the Court of Appeal say at the bottom of that paragraph, these are matters which would have affected him every day that he was at St. Michael's, not just from May 2015. And the same point can be seen at paragraph 162. That's just down at the bottom of this page and over to the next. So, adverting to the danger of double compensation, but then reverting to the question of the per diem award after May 2015 and why it's justified. Because it, over the page, exposed him to the likelihood of the incidents which did occur, etc. That finding there as to what JM was exposed to after May 2015 is materially the same as its findings in respect of his right to the security of the person for the entire period. So these findings would entirely support a per diem award from the beginning of JM's period at St. Michael's. They certainly don't support a decision to interfere with the judge's decision to make that award.
No, but reading 158 and 162 is quite difficult because they try to they are looking at the matter incident-free, and yet in 158 it's quite clearly it's the inappropriateness of the location of his detention and what that involved, which included the incidents that they're justifying the protection of law award from the later date. So I can understand why you're saying you don't want a separate award for the incidents, but you could be content with the per diem. Yes.
It's of course what the Court of Appeal is saying would justify a per diem and an additional award. But they didn't order that, and neither did the judge. And I think the best I can do for JM is to restore the judges.
Yes. Well, you haven't got any cross appeal or anything, and and anyway, it's a matter of whether the judge was plainly wrong. That's what they should have been asking.
That's exactly right, my lord. Yes. Right. So, yes, for that reason, I say they shouldn't have interfered with the judge's award of a daily rate. Going on to the protection of the law point,
I thought we were on protection.
We just finished the security of the person point, my lady. And I'm sorry, there is some confusion because we were looking at the Court of Appeal's reasoning on protection of the law.
You're saying the logic of that reasoning applied equally to
Yes.
security of the person.
That's right, my lord, yes. But I also say, as my lords anticipated, on the Court of Appeal's findings, it's also true to say it wasn't justified in setting aside the judge's finding that the protection of the law was breached for the entire period. And I'd take it just from the Court of Appeal's own reasoning. Starting at paragraph 60, which is page 827. So, a reference to CPSAD, and the specific difference in CPSAD, as your lordships may recall, was there was a specific statutory requirement that came in with the New Children Act that the children involved in that case be detained in a community residence. These were young offenders. And the Court of Appeal goes on to say, in the incident case, there's no such specific statutory requirement. However, an analysis of the circumstances in which he came to be detained, his condition, the unsuitability of St. Michael's, the obligations of the state under international conventions, and 5, the new legislative framework, they all necessarily lead to the conclusion that the law that came into existence on May 18th, 2015, provided for JM to be housed in a safe environment. And that's the reason why the Court of Appeal says his right to protection of the law was breached after that date. I say the implication, though, of that decision is that only began on that date, is that before that date, the law did not provide for JM to be housed in a safe environment. And that has to be wrong. The law always provided for JM to be housed in a safe environment. And elsewhere in its judgment, the Court of Appeal agrees with that position. At paragraph 83, the one I showed your lordships and your ladyship earlier, that's at page 842. The detention at St. Michael's facilitated the abuse and treatment and exposure to violent and bullying behaviour, the very matters that the old Children Act and then its replacement were designed to avoid. So the law always required JM to be housed in a safe.
Yes, I mean, the old Children Act allowed the state through the magistrate to place the child in the care of a relative who could cope with the child, or an orphanage.
Yes.
And that was it.
I agree with that position, my lord, yes.
And I mean, it starts off with the child in the initial period having to be in safekeeping, and then it must be implicit that the Section 12 options are consistent with safekeeping thereafter.
Yes, my lord, I agree, and it's also consistent with the other provisions we looked at earlier in Section 44. Whenever a child of this age comes, whenever a child of this age comes before the court, they're to be housed in an orphanage rather than a young offenders institution, because JM was younger than 10.
Yes,
young offenders institutions are only for over 10s. But when a child comes before the court for any other reason, they're going to be housed in an orphanage and not a young offenders institution.
Yes, I mean, Section 44 is part of Part 3, which is referred to in Section 12.7.
Yes.
Yes.
And you say if there isn't an orphanage that's able and willing to take them, then that's a breach by the court, by the state of its obligation.
Yes.
Yes.
And in CPSAD, that was treated as a breach of the right to protection of the law. And that's how the Court of Appeal put it themselves at paragraph 83. They actually go on to speak in terms of these matters informing the content of the right to protection of the law. So I say the Court of Appeal did not identify good reasons for setting aside the judge's finding that JM's right to protection of the law was also breached for the entire period. My further point concerns the differential, because the third way in which the Court of Appeal differed from the judge was in setting aside her decision toward a higher daily rate at St Anne's. And its reasons are set out at paragraph 186, which is at page 875. So the Court of Appeal discusses the judge's reasoning. Well, the judge's paragraph 230 doesn't. It says the court, in addition to the documentary evidence, paid a visit to St Anne's and to the seclusion room. However, the evidence of mixing with adults and the fact that the court found that the seclusion rooms were tiny, gloomy, and scary could not be sufficient to displace documentary evidence that the conditions at St Michael's were no better than the conditions at St Anne's. In my submission, that's the Court of Appeal simply substituting its own assessment for that of the judge, and that's impermissible. And there's a particularly wide margin of appreciation when it comes to assessing damages. The judge's assessment that JM suffered more harm at St Anne's was based on her visit to St Anne's. The Court of Appeal didn't visit St Anne's. But it's also based on her overall assessment of the conditions at both institutions, as she sets out at page 415, at 230 and 231. Perhaps I can just give you references, because the findings, when the judge is assessing the harm at St Anne's, she will have in mind her findings about St Anne's, and they included the following. We start at 374.
Sorry, 374.
Page 374 or?
374.
Yes, sorry, I should go 373, I'm sorry, because...
So now you're referring to some findings which you say justified her...
These are the judge's findings about conditions at St Anne's. So
Right.
I got a wrong reference there. It's 372. And she points out that it was a major part of the plan for management of Joshua's needs was seclusion.
I'm awfully sorry, which paragraph?
Where are you reading from?
111, in the middle of paragraph 111.
Middle of paragraph 1. Oh, a major part of the plan.
A major part of the plan. And she goes on to cite instances over the page. The instances
That
also...
was in St Anne's, wasn't it?
Yes, that's right. I'm saying that when the judge assessed the harm done to JM at St Anne's and said on her view it was worse at St Anne's than St Michael's, she's having in mind these findings, amongst others. And she, at paragraph 112 at 374, she notes physical restraint as well as seclusion. And she, over the page at 115, she makes the point that the behaviour that led Joshua to be placed into seclusion so as to control him was precisely the behaviour you'd expect from somebody with his syndrome. And if he'd been in the right accommodation, of course, people with better knowledge, better training, different facilities, may well have been treating JM more appropriately for his needs and to deal with his symptoms. And at page 386, she says, this is paragraph 150. Sorry. I've got a bad reference against. It starts at 385. that Joshua was a minor at an adult institution, and at the end of that paragraph, it was an institution which was not able to manage his symptoms. The appropriate facility would have been able to. And at page 169, sorry, paragraph 169, which is 391, St. Anne's was wholly inappropriate for the care of Joshua. So it was findings like these that inform her assessment that J.M. suffered more harm at St. Anne's, and she was entitled to make that assessment. To the extent that the Court of Appeal identified specific errors, it did so at page 874, paragraph 183. These are two errors that the Court of Appeal purports to identify. And I say both of those objections are insubstantial. As to the question of seclusion, the judge saw the conditions in which J.M. was secluded, and she took the view that he had suffered as a result, and she was entitled to do that. A difference between her and the Court of Appeal as to whether that seclusion amounted in law to solitary confinement or cruel and unusual treatment is immaterial to her factual assessment of his suffering. So that's an immaterial objection on the part of the Court of Appeal. And as to the suggestion that the judge was influenced by a perception that J.M. was receiving inappropriate treatment for a mental illness when he hadn't been diagnosed with one, I say that's also insubstantial because the judge was entitled to take into account that J.M. was not receiving treatment appropriate to his needs. That's beyond dispute. His treatment plan in 2015 wasn't being implemented at St. Anne's. And it's also not in dispute that at St. Anne's, J.M. was being administered with psychiatric medicine to control his behaviour. That's in the evidence of the doctor himself at page 1427, paragraph 16. That's not therapeutic administering of medicine. It's
What page, please?
page 1427, paragraph 16.
Thank you.
That's not therapeutic administering of medicine. It's to control his behaviour. And when you compare, for example, the authorities' treatment plan in 2015, which the reference which is page 1014, or you compare the treatment given to JM at the Child Support Centre from 2017 onwards, which you can see in the psychologist's affidavit at 1413, you'll see there's no mention of the same drugs being used to control JM's behaviour when he's properly cared for at the CSC, and there's no mention of those drugs to control his behaviour in the authorities' plan of 2015.
Is it right, these drugs, they weren't just sedatives, they were antipsychotic drugs?
Well, the Court of Appeal criticised the judge for checking that on Google, but it's also in the evidence of JM's mother, which was undisputed, that these are antipsychotic medication. And you can see them being applied time and again, PRN, which means as circumstances require. In other words, when his behaviour gets unmanageable. I can give you some page references for those. There's a prescription list at page 1012, and there are in the daily reports there are instances of drugs being administered either PRN or as a result of an outburst or an unmanageable moment at page 1471, 1473, 1474, 1478, among others. So, the objection that the judge went against the medical expert's evidence, by the way, not an independent expert, it's the doctor at St. Anne's. The objection that she went against the expert evidence in finding...
Well, it wasn't expert evidence, you were going to take technical points.
No, it wasn't. It wasn't, no. But the objection that she went against the evidence of a doctor in saying that his treatment was inappropriate is insubstantial when it's undisputed on the facts that he was being given psychiatric medication to control his behaviour, and he wouldn't have been given that if he was being properly cared for example, at the CSC. So she's entitled to assess for herself that the harm he suffered at St. Anne's was worse than at St. Michael's.
I think I saw a reference in one of the documents we were shown earlier to him being assessed when he was in the care of the Children's Authority to see whether he might have suffered liver damage because of the known side effects of this medication.
Now, that was he was being given regular medication to control impulsive behaviour, and then he was being given other medication to sedate him when outbursts took place. But you're right, Milo, that was the regular medication that there was a concern it would lead to liver damage. But the point I'm making is this is not a good reason for the court to interfere with the judge's assessment that JM suffered more harm at St. Anne's than St. Michael's. She was entitled to do so. So my submission is that we would ask the board to restore the judge's compensatory award. And unless you have any questions, my lord, my lady, those are my submissions.
Thank you very much. Mr. Stephens.
My lords, my lady, I'm going to start, if I may, with the issue of the additional award of $1 million. Described by the appellant as vindicatory damages, but more properly characterised as an additional vindicatory damages, because, as we'll see, all constitutional damages serve a vindicatory purpose. I'll then deal with cruel and unusual treatment. Then, because it's linked to that in my submission, the higher per diem rate in respect of St. Anne's. And then the judge's approach to the period spent by the appellant at St. Michael's and subsequently St. Anne's, and the judge's approach to compensatory damages more generally. And finally, I should just say that I understand that the trust point, which you've not been addressed on orally, may no longer be pursued. Mr. Ranlogan confirms that.
That's right. Yes.
That is correct. So you're content that the arrangement advocated by the Court of Appeal be maintained?
Yes, please.
Thank you.
My Lord, just to complete the picture, so that your Lordships are aware, in June of this year, an application was in fact made for payment out of the sum of money ordered by the Court of Appeal on JM's behalf, so that it could be spent on accommodation which had been identified costing something more than 500,000, a vehicle 250,000, and other expenses. So I apprehend that it's because that course is being pursued that they no longer wish a trust to be imposed. There is, for completeness, a hearing in November in relation to that application.
Who is making that application?
Those instructing my learned, my learned friends are making it on behalf of their client. It's brought in his mother's name because she is his next friend. We do have a copy of the application if the board would like to see it, but I don't think you need to see it.
But in any event, no challenge has been made to the Court of Appeal's position on that point.
No.
Thank you.
What I would only add for completeness is that on instructions, it's my understanding that it is entirely in accordance with normal practice in the case of a minor for damages to be ordered to be paid into court. And certainly the CPR in Trinidad and Tobago make provision for that, and directions which can be made by the judge for payment out and so on and so forth. So, my lords, my lady, I start with the additional award of $1 million. The appellant had suggested, in effect, that the learned judge, that the Court of Appeal, rather, misdirected itself in two places. I say two places. You've been shown one of them in the course of oral submissions, but they identify in their written case a not dissimilar paragraph, and it is paragraph 19 of the Court of Appeal's judgment, which is in the summary, and that is at page 300, forgive me, 808. So this is in the summary of their conclusions. And the other paragraph is the paragraph to which you were taken at page 879, and it's paragraph 198. Now, the first criticism made in writing, at any rate, is that the Court of Appeal misdirected itself inasmuch as in paragraph 19 on page 808, it suggested that an additional award of the type identified in Ramanoop required evidence of gross negligence, malice, high-handedness, cruelty, or oppressive behaviour on the part of the state. With respect, that is a misreading of that paragraph of the judgment, which, as I've already indicated, appears in what is a summary of the Court of Appeal's, or I should say, Justice of Appeal Raj Kumar's conclusions. I'd make 2 points specifically. First, the context in which the criticised observation was made is important. In Justice of Appeal Raj Kumar's view, as he summarised in the second sentence of paragraph 19, the award of damages and declaratory relief had vindicated the appellant's rights. So that's the starting point, if you like. Now, given that he had well in mind the guidance in Ramanoop, and specifically the factors said in Ramanoop potentially to require an additional award, and we see that from paragraph 195 of the judgment at page 878, where by reference to a case called James that was decided after Ramanoop, the Ramanoop factors are set out. So given that he had well in mind that guidance and those specific factors said in Ramanoop to justify or potentially justify an additional award, what he went on to say has to be read in that context.
We didn't leave much room for doubt in what he said in 196 and 198 about how he was approaching it.
I'm sorry, my lord.
He didn't leave much room for doubt when he spelt it out in 196 and 198.
Well, my lord, can I come
but he said that institutional inertia couldn't give rise to an award.
No, my lord, he says, with respect, I'll come to 198, he says the institutional inertia. Now, my submission is going to be that he was talking there about the institutional inertia in the circumstances of this case, not institutional inertia generally or per se. But the point I make first in relation to paragraph 19 is that he was not purporting to give an exhaustive list of factors required to justify such an award. Rather, what he was obviously doing was giving examples of factors that could justify such an award, and he was doing that having already taken into account what was said in Ramanoop and concluded, as the Court of Appeal did, that a compensatory award was sufficient and that an additional award was not required. Now, as to... I'm
Give
sorry.
us a paragraph number a moment ago about Ramnu, and I'm just...
I did. It was 195.
Well, why wasn't he there? If it's based on his assessment that a compensatory award is sufficient, that's just his view. I mean, that's not a basis for saying that the judge has made an error of law.
Well, my lord, it may be, because if he's right in saying that compensatory damages was enough or were sufficient, one looks at what the judge ordered and one sees what she took into account in arriving at her assessment of compensatory damages, one may begin to understand, and I'll come to this, why it is that it was sufficient, because of the factors she took into account. But, my lord, can I just deal with 198, because my lord has fairly put to me that, or suggested that it's clear there that what the Court of Appeal is saying is that institutional inertia is not enough. Well, with respect, what the learned judge there says is the institutional inertia, as opposed to deliberate inaction or malice or other deliberate conduct, could not be a circumstance that give rise to an award of vindicatory damages. And I submit that what he was saying in the circumstances of the judgment as a whole, and bearing in mind that he properly directed himself by reference to the Ramanujan factors, was that the institutional inertia, which is how he characterised the state's failure to take effective action, or the state's omissions in JM's case, was not such as in the circumstances of the case to justify an additional award.
Well, what was the feature of it which took it outside the general principle? If he's accepting that in general institutional inertia can, even without malice, give rise to an award of vindicatory damages, what was the feature that he identified of this institutional inertia which meant that it was wrong in principle to make that award?
Well,
I mean, it's pretty hard to think
well, my lord, I don't accept
when it is going to, if it isn't in this case.
No, my lord, I'm not suggesting that it was a question of him saying that it was wrong in principle in this case. What I am suggesting is that on the facts of this case and in the circumstances of this case, to which I will come, it was not necessary to make an additional award for what he characterised as institutional inertia.
Well, again, if that's how you read it, then he hasn't identified a respect in which the judge was plainly wrong or wrong in law. He's just taking a view about what he thinks in the circumstances is appropriate.
What he has said, in terms with respect, is that the award which was made by the Court of Appeal in substitution of the judge's award, which was compensatory in nature, was sufficient. And so what he's articulating there is that, taking account of what the appellant was subjected to and the breaches of his rights, a compensatory award was sufficient. Now, when we look at what the judge did, we will see that she too, in making her compensatory award, took account of all the things that happened to JM and all the matters of which he complains. And in those circumstances, we submit that on the judge's own reasoning, it wasn't appropriate to make any more than a compensatory award. But can I take you to that in a moment and just...
Well, if his argument is that because you're being compensated for the harm you've suffered, it then is inappropriate to make an award of vindicatory damages, that isn't correct in law, is it?
Well, the question is this. All constitutional damages are vindicatory. The question which the court has to answer is whether the infringed rights have been sufficiently vindicated or compensated. Now, in a particular case, it may be that that purpose is served by purely a declaration. In another case, it may be that it is served by a combination of declaratory relief and a compensatory award. In another case, the appellant says this case, and I don't accept that, it may require more than that, an additional award. Now,
well, if you're re-arguing the point in the Court of Appeal, they might take a different view, but I thought here that they were saying why the judge had gone wrong in principle.
Well, my lord, they are, in the sense that what they're saying is a compensatory award is or was sufficient, nothing more was required. The institutional inertia in this case did not require more. And when we look at what the judge did and why she came to her decision in relation to compensatory damages, we will see in my respectful submission that, in effect, she had regard to all the factors in Ramanup in making that award, and therefore I will be submitting that her additional award was simply duplication.
So, if I can just be clear about the submission. So you're not taking the point that as a matter of principle, vindicatory damages are only available for deliberate or malicious conduct. That is not,
My Lord,
any part of your submission.
My Lord, I am going to just allude to some authority that appears to suggest that you can only have vindicatory damages of this type, an additional award, in circumstances which are analogous to those in which exemplary damages are awarded at common law, because there is some authority to that effect, and that might support the proposition. But what I do accept, what I do accept is that there have been cases in which awards have been made absent such factors, and where the circumstances could be equated to institutional inertia. Malone and Friend has adduced examples of those, and I don't suggest that there have not been such cases.
Well, are you saying they're wrong? I just want to be clear. Are you saying those cases are wrong and you're relying on this other authority, or are you accepting that they're correct in principle?
I accept that in an appropriate case, I'm going to call it institutional inertia, but I don't equate it with what happened here. Institutional inertia, absent those particular things, could give rise to a constitution.
Okay, otherwise you'd have to argue that Elaine was wrong.
Well, I would, although what I would say about Elaine is that what the Privy Council actually said in Elaine is that the Court of Appeal's categorisation of what happened, or characterisation, I should say, of what happened in that case as institutional inertia was mild, and they described rather more than that.
Yeah.
But can I just then go to what I was then going to say, which is that your primary submission, as I understand it, is therefore that the trial judge went wrong as a matter of law, or possibly was plainly wrong, to regard compensatory damages as inadequate to reflect the vindication in this case.
Well, I'm going to show you what she said in a moment. What I submit is that she erred in failing to appreciate that compensatory damages could serve the purpose of vindicating the breach of the right in the very way it's described in Ramanup, that her award took account of all the factors identified in Ramanup as potentially justifying an additional award, and therefore that, in effect, she had made an additional award as part of her compensatory award, and making a further additional award was duplication. And linking that to what I say about the Court of Appeal, the Court of Appeal's overriding conclusion was that a compensatory award was sufficient. And that is certainly right when you look at the way the judge approached the question of compensation.
Well, I think you're saying what I suggested is your point, but you don't seem to want to agree with it. But anyway.
Well, my Lord, I may be chiefs. I'm sorry.
Okay. Thank you.
My Lord, to try and summarise the point in relation to the Court of Appeal, in the circumstances in which the Court of Appeal had clearly considered the Ramanup factors, I'll call them, and concluded that a compensatory award was sufficient, which is what I submit we also see when we look at the judge's approach, it is unsurprising that the Court of Appeal took the view that in the circumstances of this particular case, more than institutional inertia would be required to justify an additional award. Now, I did say a moment ago that there is some authority which indirectly supports the view that factors such as those to which Justice of Appeal Raj Kumar referred, for example, deliberate conduct, high-handedness or oppressive behaviour, will generally be required to justify an additional award. Inasmuch as parallels have been drawn between such an additional award and a common law award of exemplary damages in cases involving arbitrary, oppressive and outrageous use of executive power. And it's in that context that it has also been suggested that the circumstances in which an additional award would be justified, where an award of exemplary damages would not, will be very limited. Now, I ought, for completeness, just to show you that authority. Could I just take you to case of Lumba, RWL Congo? It's at 3131.
Can I just flag that I have a difficulty with this argument by drawing the analogy to exemplary damages, because we know that exemplary damages are designed to punish.
Yes.
And we're specifically told that vindicatory damages do not have that punitive element. Now, if one's looking at exemplary damages, one could understand that because punishment has to be part of the rationale, you may well require deliberate or malicious conduct. And there's been, as you will know, a big debate about that. I was involved in it myself, I think, when I was at the Law Commission, as to what the standard should actually be. But I'm not sure drawing that analogy is going to help us in a context where we're precisely not dealing with exemplary damages.
My Lord, I hope I made it clear that I do accept that there is scope potentially for a constitutional award, an additional constitutional award, in a case where the sort of factors to which the Court of Appeal alluded, I say as examples, are not present. And I also, in response to your Lordship's question whether there was any authority suggesting that those factors were required, referred to these authorities, to which I'm just briefly going to take you. I thought it only right that the Board know that there is in fact one case in the Privy Council in which Lord Kerr made an observation which is precisely along the lines of that which clearly troubles your Lordship. Can I start, though, briefly with the case of Lumba, which is at 3131, and simply take you to 3211. This was a case in which there was an unsuccessful attempt made to suggest that vindicatory damages had a role or a place in the law of England and Wales. At paragraph 256 in the judgment of Lord Kerr, he said this: for the reasons given by Lord Dyson, an award of exemplary damages is not warranted in these cases. If there is any scope for the award of vindicatory damages where exemplary damages are not appropriate, it must be, in my opinion, very limited indeed. Such an award could only be justified where the declaration that a claimant's right has been infringed provides insufficient emphatic recognition of the seriousness of the defendant's default. Now, inasmuch as awards of exemplary damages are made, at any rate in this jurisdiction, in common law, as a matter of common law, in respect of arbitrary and outrageous use of executive power, that would suggest, at least, that a vindicatory award might similarly be so restricted.
Now, that was in the context, I'm not sure what Lord Kerr's judgment, how that fits within it, but that is the case that says we do not have vindicatory damages at common law.
That's right. As I say, an unsuccessful attempt was made to argue that there should be an award of vindicatory damages, and hence the discussion. And because vindicatory damages had been recognised in the Caribbean, particularly in Trinidad and Tobago, and Ramanup had been decided, we get the discussion of Ramanup. But that is picked up on in a subsequent case, which is a Caribbean case.
Would that be, should we come to the subsequent case after the short adjournment?
My Lord, certainly.